Yes, sir. You can start now.
Okay, please. So good evening, everybody. Today the topic is bail, concept of bail, the types of bail, the grounds which generally are considered by the court while granting bail or rejecting bail. And then we will also be covering some practical aspects. So, now, as you can see the screen, the concept of bail. What is the concept of bail? Bail is generally an assurance that the accused shall appear before the prescribed place at the prescribed time, which may be the court also, before the authority without any fail and shall not abscond. By giving bail to an accused, which also means threat to a society. So the authority granting bail has to maintain a balance between these conflicting interests. Now, what are these conflicting interests? These conflicting interests are that on the one side is the liberty of the individual, and the other side is a threat to the society, that by enlarging him on bail, he might commit the offense once again, or he might commit some other offense, or he might tamper with the evidence, or he might, you can say, threaten or induce or make or try to tutor the witnesses. So the authority before which the bail application is moved faces all these conflict of interests. And so bail is basically a balance. A balance has to be drawn between the two interests. So bail is basically balancing the two interests. Now I'll come to that. What are the types? Before that, I would like to present the bail bond before you, because you should be familiar as a law student that what is a bail bond. Let us look what is a bail bond. Yes, here we have bail bond. What it looks like. Form number 45, bail bond and bail bond for attendance before officer in charge of police station of court. Section 436, 437, 438, 3, and 441. In the court of Sri so police station under section so FIR number. This is the performer you get before. This is a set performer, and next date of hearing sent to jail on so. Now comes the bail bond. First will come the accused. I so son of Sri so residence of so having been arrested, detained without warrant by the officer in charge of the Falana police station for having been brought before the honorable court, charged with the offense of so under section so and required to give surety for my attendance before such court, and that I shall attend such officer or court on every day on which an investigation or trial is held regarding such charge, case of my making default, herein myself to forfeit to the government a sum of rupees so and so to be decided by the court or the authority, that is the police. Now this is called personal bond of the accused. When we call a bail means personal bond along with the bond of the surety, assurance of the surety. Now what is surety? Surety is a person other than the accused who can guarantee his presence before the court or any other authority in future dates, and who is ready to undergo forfeiture of the amount promised by him. Now comes the surety's bond. I, so and so, son of Sri and so residence, hereby declare myself for the above said Sri so and so, that he shall attend the officer. Now the word is he is the accused. The accused shall attend the officer in charge of some police station or the court of Sri every day on which an investigation the charge is made on trial of such court. I'll come to the last line. And in the case on his making default herein, I bind myself to forfeit to the government. So this is what the bond of a surety. Now comes the affidavit. Affidavit has to be filled by the surety. Generally, seventh is ticked generally by the surety that I have an FDR. Generally, the courts there here in Delhi, they ask people to surety deposit FDR, fixed deposit receipts, issued by bank so and so for rupees, whatever amount is decided by the court. Equivalent to that, an FDR is created and deposited in the bank with the court. And the court, what it does, it endorses a stamp on the back of the FDR. So deponent as an affidavit is prepared. So this is the specimen of a bail bond, form number 45. Okay. Now I'll come back to our lecture. Types of bail. What are the different types of bail? Generally, there are three types. Regular bail, which includes bailable as well as non-bailable offenses. Anticipatory bail, as well as interim bail. Types of bails. Regular bail. Now, if you call, offenses are of two types, bailable as well as non-bailable. The difference between the two is, in case of bailable offenses, as you must have read in your syllabus, the accused has a right to get bail. The word used in the CRPC is shall, means he has the right, as a right he is seeking bail. It is not in the discretion of the court whether to reject or to accept the bail, grant the bail. But here, as a right, he is asking, at the court or the officer in charge of the police station is bound to enlarge him on bail, provided he is ready to give bail. Correct? Now we'll see the bail in bailable. Section 436 of CRPC. This talks about bailable offenses. What does it say? That whenever a person who is accused of committing bailable offense is arrested by an officer in charge of the police station, or is brought before the court, produced before the court, and he is ready to give bail, then he shall be released on bail. The court or the police station, the police in charge, has to release him on bail, provided he is ready to furnish bail. Or if he is having a poor financial capacity, in that case, the court or the officer can release him on personal bond also, without asking him to give a surety. And as an explanation to that section, it has been added that if an accused fails to give a bail within a week of his arrest, then it can be presumed by the court or the officer in charge that he is an indigent person. The word used is indigent person, or having a poor financial capacity, and so he should be given release on personal bond. That is what the explanation says. Then comes section 167. 167 is very important. 167 says that whenever a person is arrested and he has to produce, as you know, within 24 hours, the person arrested has to be produced before the magistrate, nearest magistrate. The nearest magistrate may be a person having jurisdiction to try the case, or he may not have any jurisdiction. So the nearest magistrate, whenever he is produced, in 24 hours. And the court is of the opinion that this person has committed some reasonable grounds exist, so it will commit him to custody. It may be judicial or police custody. But in case of police custody, the court cannot give him remand him to custody for more than 15 days period. So in total, the court cannot send him to a police custody for more than 15 days in total. Thereafter, the court has to send him to judicial custody. Judicial and police custody means the police station, custody of the officials of the police station, and judicial custody means custody in the officials of the central jail. As in Delhi, that is Tihar jail, Rohini jail, Mandoli jail. They are central jails. So all those persons who are in custody of a jailer, they are in judicial custody. Now, the thing is that as far as even judicial custody is concerned, the court cannot keep him in judicial custody for more than 90 or 60 days, depending upon the offense, the nature of the offense. For offenses punishable with death or imprisonment for life, or you can say imprisonment for a term of not less than 10 years, or 10 years or more, the accused shall be enlarged on bail on the expiry of this period. That is 90 days period. So they cannot keep him for more than 90 days under judicial custody also. Again, under sections for other offenses, on the expiry of 60 days, if he is ready to furnish bail, he has to be enlarged on bail. And the bail will be considered to be a regular bail granted under Chapter 33 of the CRPC, which deals with bail and bail bonds. So here the police is under a pressure to, finish with the investigation within a period of 90 days or 60 days, as the case may be, and to put a charge sheet. If they don't do so, he will be enlarged on bail. Now we come to section 436A. Now there are three sections, or I should say 436A, 437.6, 437.2, and 437.7. On all these, he has a right, no doubt, but subject to the discretion exercised by the court in his favor. Same with 436A also. Where the accused had undergone detention for a period which amounts to at least 1/2 of the maximum sentence prescribed for that offense, he shall be enlarged on bail, or he shall be enlarged. He can be enlarged on bail also, or personal bond also, provided the court decides so in his favor. Before doing that, the court has to give notice to the public prosecutor and hearing. And if the court decides that the detention should continue, the detention will continue. Or court may also say, instead of a personal bond, he has to furnish a bail. So subject to discretion exercised by the court, he has a right to get bail. But even if where the detention is continued by the court, it cannot be more than the maximum sentence prescribed for that offense. Thereafter, he has to be enlarged on bail. Nobody can stop it. Then comes 437.6. This is in case of offenses triable by a magistrate. So, where the trial is not concluded within a period of 60 days from the date fixed for the evidences, the accused shall be enlarged on bail, unless the magistrate otherwise directs for the reasons to be recorded in writing. So again here, the discretion of the court, he has a right to be enlarged on bail. Now comes section 437.2. During investigation, trial, or inquiry, anywhere where the court comes to a conclusion that, or the officer in charge also can come to a conclusion that there are reasonable grounds for believing that this person has not committed any bailable, non-bailable offenses. But there are sufficient grounds to hold an inquiry into his guilt. There, he shall be released on a personal bond with surety, without surety, sorry, only on personal bond, to ensure that he appears in the court on the later dates. Then comes section 437(7), where on conclusion of a trial, the court comes to a conclusion. The trial has concluded, but the judgment has not been delivered. Before the pronouncement of judgment, the court has come to a conclusion. Person has not committed the offenses he has been charged with. Again, he has to be released on bail, on personal bond, just to ensure that he appears before the court on the date of pronouncement of the judgment. Now, we'll discuss this. This was something about bailable offense. Now we'll come with non-bailable offense. Non-bailable offense are those offenses where bail doesn't become a right. It is just a matter of prayer sought from the court. And it is in the discretion of the court whether to grant, enlarge him on bail, or to commit him to custody, judicial or police. So what 437 says is, officer in charge of police station, any person who has been accused or suspected of committing a non-bailable offense is arrested by the officer in charge of the police station or is brought before the court. In that case, he may be granted a bail. But under two conditions, there are two clauses which I have mentioned here. Clause 1 and 2, in which the officer in charge of police station cannot grant the bail. Only court can grant. What are those? One is where 437(3), where the offense, we'll discuss that also. What is 437(3)? Where 437(3) is involved, or there are reasonable grounds for believing that this accused has committed an offense punishable with death or imprisonment for life. And secondly, where you can say, I'm sorry, first category is only where this culprit is, this accused is accused of, the offense relating to that accusation is punishable with life or death. And secondly is where the offense is a cognizable offense and the accused has been convicted previously with this offense, which is punishable with death, life, or imprisonment of 7 years or more. Or the offense is cognizable offense, and on two previous occasions also, the accused has been convicted of offense punishable with 3 or more years, but not less than 7 years. So these are the two clauses. Now, again, under clause 1 and 2, the court can release the person on bail, provided he is infirm, sick, or a woman, or person under 16 years of age. Then, under 2 also, the court can do so if it thinks it's to do on the basis of special reasons to do so. The court has to record the special reasons. Now comes 437(3). This applies to offense punishable with imprisonment up to 7 years or more, or an offense under chapter 6, 16 or 17 of the IPC, or the abatement, conspiracy, or attempt to commit any of said offenses. That same section 437(3) says, now the power is given to the court, not to the officer in charge of the police station. The court shall impose the conditions, the following 3 conditions, apart from some special conditions. What are those 3 conditions? The accused shall appear before the court whenever, as per the terms of the bond. He shall not commit the offense, the similar offense, the same offense again if he is enlarged on bail of which he is accused. And third is, he shall not give any threat, inducement, or promise to any person acquainted with the facts of the case so as to dissuade him from speaking before the police officer. And also, he shall not tamper with the evidence. These conditions, along with some special conditions, will be there. Then comes 439, very important section. These are the special powers given to the High Courts or Court of Sessions to grant bail. The High Court, the Court of Sessions, may grant bail to any person accused of any offense or may modify or set aside any condition imposed by a magistrate. 2 things they can do. They may grant bail to any person accused of any non-bailable offense, because bailable he has to get the bail. Offense here means non-bailable. Then they can modify or set aside the order passed by any magistrate. Terms and conditions imposed by a magistrate while granting bail. Then again, 439 says that notice to PP is compulsory under 2 conditions. First is where the this offense is triable exclusively by the Court of Sessions, or if not being so, it is triable by some other court, but the offense is punishable with life. There it has to give a notice to the PP so that it can appear, set its object, give its objections, the court can consider it, pass an order. Secondly, it says that where the offense is under section 376(3) or 376(AB) or 376(DA) or DB, they're all sexual offenses. They have been recently added last 4 or 5 years to IPC. There the court has to give again a notice to PP and hear it properly, because they are grave offenses. One more thing about 439, similar to 437, is the court granting bail here or High Court or Court of Sessions may cancel the bail granted by any court below Court of Sessions or High Court. So subordinate court, whatever bail has been granted, may always be cancelled by the Court of Sessions or High Court, and the accused may be committed to the custody of the police. Types of bails here. Again, now we come to the second types of bail. First, for the regular bail. Now we come to anticipatory bail and interim bail. What is an anticipatory bail? Anticipatory bail means whenever a person has reasonable grounds to believe that he may be accused of a non-bailable offense, he may approach to the Court of Sessions or to the High Court seeking a direction that whenever the police takes him into custody, he should be released on bail, provided he is ready to, he is in a position to give bail at that moment. So This is what 438 deals with, anticipatory bail. Now, some factors which are to be considered that have been mentioned in the section itself. I'll just go through it. Nature and gravity of offense, antecedents of the accused, including any previous conviction, possibility of fleeing if given in bail, whether the accusation has been made with the intention of maligning the reputation. These things have to be considered by the Court of Sessions or the High Court before granting any anticipatory bail. But again, before granting any anticipatory bail, and if the court, now the court can do only two things. First, after hearing the application, that will reject. It will reject, the matter will end there. But if it decides to proceed with the matter and issue a note, then what will do? It will grant an interim bail. The court finds a substance in the application. Interim bail means bail till the next date of hearing. And also will issue a notice to the public prosecutor, so that he can appear on the next date on the final hearing, give his objections, and the court can finally decide on the application for anticipatory bail. So that is what I have written here: rejection of the application or interim bail. Give interim bail notice to PP or SP is must. Again, it is not applicable to offense under section 376B, 376 AD, 370 DA, and 370 DB. It means in these four offenses, anticipatory bail is not applicable. You can't invoke this section if you are accused in these four offenses. Yes. Now, what are the factors to be considered while granting bail? As I have written, bail should not be passed in a mechanical manner without proper application of judicial mind. At this stage of bail, a court is not supposed to inquire into the merits or demerits of undertake the analysis of merits. Yes, that is very important. People confuse bail application with you can say analysis of the case. No, bail court has just to make a prima facie view whether there are grounds to enlarge the person on bail or not. Court cannot go sift evidences or weigh evidences or go into the analysis of the case, because that is the ambit of the trial court. The bail granting, the court granting or not granting the court, inviting the application may or may not be the trial court. So that is what the provision is. Now I'll say what is the factors. Again, as I told you, whether there is a prima facie or reasonable ground to believe that the accused has committed the offense. Nature and gravity of the accusation, that is very important. Severity of the punishment in the event of conviction. Danger of the accused absconding or being released on bail. This is one of the most important, in fact. Character, behavior, means, position. This is also very important. This greatly influences the court. As a student, whenever you draft an application in your drafting exam, always include these things, two things. Likelihood of the offense, again, it's very important, likelihood of the offense being repeated. Reasonable apprehension of the witnesses being influenced, and danger of course of justice being thwarted by the grant of bail. 3, 4, and 5, 6, they are very important. They should be included in the application, always. One more thing which I like to address here is that bail orders, whenever the court decides not to grant the bail or to grant the bail, the order has to be a reasoned order, proper reasoned order. It should always be a proper reasoned order. What it means is, it should be supported by reasons. Whatever the court thinks, whatever the court thinks after application of the judicial mind. Now, after all this, I come to forfeiture and cancellation of bail. Now, section 446 talks about forfeiture of the bail bond. Bail bond, as I showed you earlier. Now, what is the purpose of the bail? Purpose of the bail is that person will appear before the court or the police officer in charge of the police station who has granted the bail. He will cooperate during investigation. He will cooperate during the trial or the inquiry conducted by the court. If he fails to do so, the bail bond gets forfeited. And then what will happen? The court will issue a notice. Notice to the person who has bound himself or herself by the bail bond. He may be a surety in case of a bail. So a notice will be issued to him. And a show cause notice that why should not your amount or the penalty should not be imposed upon you. And he has to show cause. And if the court finds that there is no reason of failure to appear, the court will forfeit the bond, ask him to pay a penalty. Now, there can be, if he is not able to pay a penalty, the person bound by the bond, then it will be realized from him as a fine. Fine under CRPC. And if both things are not possible, that is, he has not been able to give a penalty, fine also cannot be taken out from him for some reason, then the court can put him behind bars for a period extending up to 6 months. And then comes section 446A, the cancellation of bond. What does it say? Cancellation of bond, it says the moment it is forfeited, the bond will stand cancelled. The bond will stand cancelled and the accused will be taken into custody. If he is before the court, or the police will be asked to nab him and arrest him. Cancellation of bond. Now, then comes precedence. Yes, there are certain judgments you should know. It is important for you for drafting purpose also. In Asu versus State of Rajasthan, the Supreme Court says that the direction that a bail application shall be disposed of normally within 1 week. Now, I think it talks about bail application under section 437, 439. That is non-bailable offences. Then in Nagpur Parinda versus State of Odisha, Honorable Supreme Court noted that the accused has a right to be released on bail under this provision. Section 167 of CRPC, that is IAS. Even in serious and ghastly types of crimes, in notorious crimes also, in very grievous crimes also, section 167, if 60 days, 90 days period has expired, and he shall be released on bail. In Union of India versus Nirmala Yadav, the Honorable Supreme Court held that magistrate should decide the application for statutory bail on the same day it is filed. Statutory bail means bail for bailable offences. He has a right to get the bail. In Arnesh Kumar, this is a very important case, 2014 case. Everybody should know that the state of Bihar, the Honorable Supreme Court has made a sweeping change in connection with the offence punishable with imprisonment of a term extending up to 7 years or less than 7 years with fine or without fine. It has now become mandatory in such cases for the police to serve a notice upon the accused within 2 weeks from the institution of the case and thereafter hearing. So finally, now the police cannot straight away. This is what is happening in Delhi. The police cannot straight away arrest him in these kind of offenses up to 7 years. He has to be given a notice by the police. The police will ask him to appear before him. And thereafter, after hearing the accused, the police will decide what to do, whether to arrest him or not to arrest him. Also, they have been given now provided with a checklist. The checklist is something which is the requirement under Section 41. 1, Clause 1, B2, Clause 2 of subclause 2 of Clause D of subsection 1 of Section 41 of CRPC. There are certain requirements, certain criteria on which the police officer has to decide certain things. And now the checklists have been provided to fill. Now the police is required to fill those checklists, and the checklist has to be forwarded to the magistrate. In case, along with the accused, if they have arrested the accused, in case they have not decided not to arrest, it has to be given within 2 weeks forwarded to the magistrate within 2 weeks, so that the magistrate can apply his mind and ensure that the arrest has been made in accordance with law or not. So that was on precedents. Now I'll share with you an application which was put before the court in 2020 by my firm's partner, Mr. Rajesh Rai. This will give you some yes. Before the Honorable CMM is produced before CMM, Dwarka District Court, in the matter of state versus this is how it is mentioned there. Sharap, because state case may be most probably a non-bailable case. So state will be prosecuting. Cognizable, sorry, it's a cognizable case where FIR has been registered. And if you don't know the difference between definition of cognizable case is that in which the FIR has to be registered, police can investigate thereafter and arrest a person without a warrant. State versus Shadab Malik. Then comes FIR, as you know, section 420, along with joint liability 34 IPC. Police station Palam, you have to mention these 3 things. It must. Then comes the application. Application under section 437 CRPC for grant of bail. Therefore, just go through it. First is formal para. Second comes again formal para, showing that he had been arrested, from where he was arrested. Now comes the real content. It has been falsely implicated. Nothing is to be recovered from the accused. And later on, it will say that nothing has been recovered. In fact, received from the complainant was transferred in the account of another co-accused, and he was the sole beneficiary of the alleged fraud. No role was ascribed to the applicant accused. Therefore, in the interest of justice, regular bail requirement that no recovery of incriminating material has been effected. This is very important to show that he is innocent. Now, this is just a prima facie, because court has to just look into the prima facie from a prima facie. Then it says all the evidences have been recovered in electronic form, cannot be tampered, nothing else is to be recovered, so is to be enlarged on bail. Applicant accused has deep roots in the society. There is no likelihood of him fleeing from justice if he is enlarged on bail. Commencement and conclusion of trial is going to take a long time. Custody of applicant accused is no more required. It is settled legal proposition that the accused cannot be kept in judicial custody as a punitive measure. Therefore, it is imperative The applicant accused be enlarged on bail. That the applicant accused without prejudice to his rights desires to compound the offence with the permission of the Honorable Court. Therefore, it is prayed that the applicant accused may be granted bail. Again, very important, every date he will present shall abide by all the terms and conditions of the bail. Sound surety to the satisfaction of this Honorable Court, time of admitting him bail. For further investigation is required to be made. Present applicant accused, however, the applicant agreed to an investigation. He will cooperate with the investigation, that is what is said. So, I should be granted bail to the final dispute of the case of justice. And what copies have to be annexed? FIR. FIR has been copy of the annexed. Because the case, the basis of the case is FIR, in case of non-cognizable offences. So that was all as far as lecture is concerned from my part. Any questions you need to raise, can raise. Do you want to raise any questions?
Yes, sir. Thank you so much, sir.
Please.
Now I would like to request all the participants, you can unmute yourself and ask the question directly to sir. I request all the participants to ask the questions one by one.
Hello, sir.
Sir, I would like to ask you a question, sir. Suppose a person receives a call from a police station that there is such and such complaint against you, and it is a cognizable offense, and he can be arrested. So, in that case, should he wait for is it a grant of 2 weeks? Can the police come after 2 weeks and arrest him? Or should he apply for anticipatory bail in this case?
What you are saying is that he has been accused of a non-bailable offense.
Your Lordship, it's suppose 498A, suppose.
Correct. Okay.
So he gets a call from a police station saying that they have received a complaint against him, and a week has passed, but nothing has happened.
Yes. So what has to be done is he no doubt what you now I get it what you're saying. 498 has been this charged against this person. So
right, sir.
7 years is the maximum punishment. The police is going to throw a notice upon him. They cannot directly arrest him.
Okay. So he has to wait for the notice. Should he apply for anticipatory bail in such a case?
Anticipatory bail in this matter, court will naturally see. Anticipatory bail, naturally court will ask whether FIR has been lodged or not. If FIR has been lodged, because after for grant of anticipatory bail, generally what the Court of Session, the High Court, what they ask is whether FIR has been lodged or not. Only a complaint has been received in the police station.
Yes, sir.
Will not entitle him practically for anticipatory bail.
Sir, can he ask for a copy of complaint from the police?
Yes, he can ask because he's been accused, so he can ask.
Yeah. Okay. So there is no need for anticipatory bail.
See, theoretically he can approach, but practically what I'm saying is the courts generally ask for whether FIR has been lodged or not.
Yes, sir.
Because investigation starts, the power to arrest starts only after FIR. And here it is just a preliminary stage where the complaint has been received. The police has to ascertain the accused persons.
Okay.
FIR has not been registered here. Preliminary investigations they are going on.
Yes, sir.
Is what is the case.
Right, sir. Thank you, sir. Thank you so much.
Please, please.
So I have a question,
Yes,
Rhythm
yes,
here.
yes.
Thank you for your lecture, sir. So my question was whether in cases of negotiable instruments, the bail provisions which apply are the same, and
Yes,
if
they are
they
the
are
same.
the
They are
same,
bailable
so
offenses.
yes, sir. So in that case, if the accused is traveling from another state to appear, and then the court says that you have to execute a bond, and then as you showed us in a specimen that in Delhi fixed deposit receipt is generally required. So does he get time to arrange for the FDR, or he's supposed to carry an FDR with him? And if yes, then how does he know the amount?
Generally, what we do is to save time and inconvenience. We just, whenever he appears, we ask him to appear along with the surety.
Okay,
so that there and there only it gets enlarged.
So, sir, but so can the person against whom warrants have been issued know beforehand for what amount he will have to execute for present?
Then and there only the court will ask you that maybe not an FDR, maybe some other thing also. The court will give an order the amount to be deposited, or the equivalent things to be deposited.
Okay, sir. Thank you, sir.
Sir, can I ask you a question, please?
Please.
So what I wanted to thank you a lot for your lecture. It was really enlightening. I'm facing this situation presently that if an intervention application is allowed in our anticipatory bail application, and it is partly allowed that the intervener can just give written arguments and assist the public prosecutor, nothing beyond that.
You
now
mean
considering
intervener means the informant?
Absolutely, the complainant, the complainant. Absolutely. This is not a anything to do with a sexual harassment case. It's an economic offense.
Yes.
Considering that, can an application, considering section 462 also, that no modification can be done to a judgment which is passed by a district court or a high court when it comes to anticipatory bails or bails, can an application for modification of that order can be filed for arguing the matter?
You are saying 462.
Or does he need to go and appeal? He can't modify before the same district judge.
Okay. You are talking about anticipatory bail.
Absolutely, sir.
You are referring to 462.
Yes.
462 talks about modification of the order.
Which is not permissible in this.
Which is not permissible. Okay. Okay.
So in an intervention application which is already decided that he has to just assist and give written arguments, can he further file an application for modification of that order? Or does he need to go and appeal?
He can give. Okay. You are saying. Okay, sorry.
Yes. It will be in violation of 462, if I'm not mistaken.
Yes. He can go and appeal. He
has to pertinently go and appeal because it will be in violation.
Against him. Something goes against him. Yes.
Okay. Thank you so much, sir. Thank you so much.
Okay.
Good evening, sir.
Good evening.
I had a question.
Yes.
So my question is, like we see in a lot of high-profile cases now, like in the case of Navika Kumar, the anchor, or the Vadhwanis for the Mumbai mall burning case, that the court allows protection from arrest, either the Supreme Court or the High Court. So does protection from arrest mean the same thing as anticipatory bail?
You can say maybe I've not seen the order, but maybe an interim bail also.
Okay, sir. Thank you. So another question I had was that in the factors to consider during a bail, the court cannot appreciate any evidence, but is only to form a prima facie opinion.
Yes.
Of the accused guilt in person. Like, is there sufficient ground to believe? So if not evidence, how, as a defense, how do you prove, if not by furthering evidence, that there is no reasonable ground to believe that the accused person has committed the crime?
Yes. So prima facie means you are asking what is prima facie and what is trial. Is what you are asking?
No, sir. I'm saying, if, like, from the defense's side, if you cannot further any evidence, how do you prove that the accused there's no reasonable ground to believe that the
See,
accused is
the
not.
moment charge sheet, do you know what is charge sheet, Chalan?
Yes, sir. Yes.
The moment police files a charge sheet, it will file all the statements of the witnesses it has interviewed. Okay. Under section 162 of CRPC. The court will go into all those witnesses and all those statements, whether they are incriminating or not, believing them to be true at the moment for deciding the application. That's all. That is prima facie. Whether this is true or not, that is a question of trial. Understood?
Sir, I'll interrupt here. A charge sheet may be filed, may not be filed at the time of anticipatory bail. There may be cases where charge sheet is not yet filed, but you are seeking anticipatory bail. Then what would be prima facie in that case?
What will be the prima facie case?
In that case, sir, where the charge sheet is not yet filed.
Yeah. I understand. Then what the court will look into? That is what you are asking.
Right, sir. Right, sir. Yeah.
That is the 4 factors which I showed you, which is there in the section itself. That what is the nature and gravity of the offense? Whether somebody is trying to malign him, malign his reputation, or what is the position of the accused, what is his stature in the society. All these 3-4 things are to be considered. So ultimately, one thing is very clear. The position of the accused is respectable position in the society, and whether he is going to cooperate or not, whether he is going to tamper with the evidence. These 3-4 things are very important. These have to be seen, whether it is anticipatory bail or a regular bail. The court cannot ignore these vital points. These have to be considered because that is the basic, you can say, reason for rejecting the bill.
Sir, as he just said that in cases of high-profile cases, if the person is influential, you think that can entitle him to get bail?
High-profile cases, you are talking of the accused, economic offenses you're talking about, is it?
Yeah, if the person is influential, then are the chances of getting bail?
One thing, let me make it very clear. In bail matters, court has a very vast jurisdiction, has a vast discretionary power. In other matter, it doesn't have a vast discretionary, but in matter of bail, so it all depends that what the court is thinking at that time and by what argument or you can say material it has been influenced. So high profile case, maybe they are able to engage big shots for themselves and big shots are able to convince the court easily. That may be a reason.
Right, sir. Right. Thank you, sir. Thank you.
Okay.
So I just had another question for you. In the sample application that was shown, there was one averment which says that without prejudice to the rights, the applicant would like to compound the matter. Sir, out of your experience,
I think what has happened generally, applications maybe that may be a, you can say, unwanted paragraph.
Absolutely, because sir, I think out of your experience, would you say that putting such an averment wouldn't that be counterproductive before the judge?
No, it will not become. He will ignore it. In fact. And it happens. It frequently happens in bail application. We will find something which is not relevant.
Okay, sir. Thank you so much.
Thank you so much, sir, for addressing each and every query. I express my deep sense of gratitude to Advocate Abhishek Awasthi, sir, for accepting our invitation and addressing the participants in such a commendable way. I also thank all the participants for evincing interest in today's session. Before concluding the session, I would like to request participants to note that tomorrow's session will be at 7 p.m., which will be addressed by Advocate Naveen Chomal, sir, who is a senior advocate practicing at Bombay High Court. Thank you so much, one and all. Thank you so much.
Thank you for listening to me.